Hello friends, welcome to EduSathi, your partner in education. In this video, we will be discussing various concepts under the law of contract like bailment, agency, contingent contracts and other concepts. So let's start. The first concept we are going to discuss under this video is contingent contract. Contingent contract is kind of a conditional contract. It is a contract to do or not to do something if some event collateral to such contract does or does not happen. Thus, it's a contract to do or not to do something which is based on an event, future event, which may or may not happen. So, this event is collateral to such contract. What are the essentials of a contingent contract? There must be a valid contract. So, when the word contract is used, it has to be a valid contract. That means all the ingredients of a valid contract must be fulfilled. Next is the performance of contract must be conditional or dependent on future event. That is, it depends upon the happening or non-happening of a certain event. It must be an uncertain future event. You do not know what is going to happen in future or in with relation to that event. It should be an uncertain one. The event must be collateral to the contract. That is, contract is based on such future event. It must be collateral to it. Contingent contract based on impossible event is void. It must not be an impossible event, otherwise the contract would be void agreement. It would not be a contract. Let's take examples to understand what contingent contract means. A contracts B rupees 10,000 if B's house is burnt. This is a contingent contract. So it's based on the uncertain future event. It's not an impossible event because there are chances of house getting burnt. So it's an uncertain future event which may or may not happen, and on the basis of it the contract is entered into between the two parties. So it's a contingent contract. Second example, A promises B rupees 1 crore if certain ship does not return within a year. So when a ship goes for sailing, it may or may not return. There is a possibility of ship sinking. So A and B have entered into a contract that he would pay rupees 1 crore if this certain ship does not return. So it's not an impossible event but a uncertain future event which is collateral to the contract. That is, contract is based on the event of ship returning or not. Next concept is wager. It is very important to differentiate between the concept of wager and contingent contract. Let's understand what wager is, then we will understand how wager is different from contingent contract. Wager is a bet, a contract by which two parties or more agree that certain sum of money or other thing shall be paid or delivered to one of them on the happening or non-happening of certain event. It's more of a money related bet wherein it is also based on an uncertain event, but there is no other interest involved in this contract. So it's different from contingent contract because in contingent contract other certain interest may be involved into it, but in this case it is merely a money contract wherein on the happening of event one of the parties would get the certain amount of money. There is no other possibility. Either one party would gain, other party would lose. So this is based on the gaining and loss of the monetary consideration. Agreement by wager are void. Wager agreement, which are bet agreements, are void. These are agreements. So these are not valid contracts, and no suit shall be brought for the recovering anything alleged to be won on any wager. So since it's not a valid contract, it's a void agreement, it's not legally enforceable or entrusted to any person to abide by result of any game or other certain event on which wager is made. Wager, that is bet, is done mostly in cases of games and gambling. So these are the void agreements. So any contract based on any agreement based on wager would be illegal one and void. It would not be legally enforceable. Thus essentials of a wager are: it's based on an uncertain event like contingent contract. There are equal chances of gain or loss. So it's based on mere gain or loss. One of the parties would gain and other would lose the money. neither the party have control over the event. It's an uncertain event, so they would not have any control over the event. No other interest is in the event except or the money won or lost. So there is no other interest involved other than the money won or lost. So this is the basic difference between the wager and contingent contract, wherein contingent contract are valid agreements and contracts. However, wager is a void agreement because it's based on the betting system. Examples are betting and gambling. So these are not legal. These are not legal in India. So it's based on wager, because in case of gambling, there's only factor involved is losing or winning the money based on the based on the event, whether your number comes in or not. Horse riding in India is not legal. However, it is very important to note that facts of the questions would really matter, because such things are not legal in India, but there are chances you might get facts from other countries also. So it's very important to read the facts very carefully, whether it's in Indian based on the Indian law or foreign law. In such cases, you would be given some of the hints in facts whether such act of betting, gambling or horse riding is legal in the particular country provided in the facts of the case. So while solving the questions related to wager, you have to keep in mind that what country it is based on. So it would depend upon the country's law. Let's take a problem. A contract dependent on conditional upon the happening or non-happening of the future event is known as contingent contract. So first principle is based on contingent contract. Second is wagering contracts are those which have equal chances of winning and losing and involve uncertain events. So two principles are given. One of them would be applicable on the facts of the case. Let's take the facts. A agrees to sell his cow to B for rupees 2000 if cow gives 10 kg milk per day, but only for rupees 10 if she fails to do so. The cow fails to give 10 kg milk. What kind of contract it is? Let's take the options. It's a transaction of sale. No, there's no sale happening. It's a contingent contract. C is it is a wagering contract. None of the above is not an option, because it would be either contingent or wagering. Let's apply the principles. It is based on a future event of giving 10 kg milk, but there's a scenario that you would get either 10 rupees or rupees 2000. So it's not a winning losing kind of a situation. You would get the money, but what amount of money you will be getting would depend upon the future event of cow giving 10 kg of milk. So it is not a wagering contract, because there is an interest of 10 kg milk and rupees 10 or rupees 2000 involved in this case. So it would be a contingent contract, right? So this is the difference between contingent and wagering contract. There is no other interest involved in wagering contract. It's a wagering agreement rather. It would not be a contract, because wagering contracts are illegal. So it is a wagering agreement. So in this case, it's a wagering contingent contract. Let's understand the concept of agency. What is a contract of agency? A person appointed to do any act for another or to represent other in dealings with the third persons is an agent. The person represented is called principal. So there is a person who represents principal. That person is known as an agent. Principle of law: contracts entered into through an agent and obligations arising from an act done by an agent may be enforced in the same manner and will have the same legal consequences if the contracts has been entered into and acts done by the principal in person. So this means all the acts and legal obligations entered into by the agent would bind the principal as if those acts and contracts were entered into by principal himself. So this means principal has authorized the agent to do all the acts on his behalf, and all the actions would bind him in person. Examples: A appoints B as his general agent. B enters into a contract for sale of A's car. A is bound by the contract. General agent means he would be representing A in all the circumstances. So if he enters into a contract for sale for A's car, this is a binding contract for A, because he has given authority to B to do all kind of actions. Another example is A appoints B as his agent to sell his crops. B enter into a contract for sale of A's house. A is not bound by this contract as B went beyond the scope of agency. In this case, the scope of agency was limited to sell the crops of A. But what B did, he entered into a contract for sale of A's house. So in this case, A would not be held liable because he had given him specific agency. Here it was general agent. So in case of, he had given specific agency, that is to sell his crops. Anything done beyond that would be beyond the scope of agency and would not make A liable. How is an agent appointed? This is merely for theoretical purposes. You can just read it out and you would understand the mode of and manner of appointment of a agent. One could be express appointment. For example, A appoints B to represent himself. A may appoint B as a general agent, or A may appoint B for specific purpose. So it's an express appointment like we discussed in the previous example. Necessity. A was B's employee. B asked A to take a huge consignment of fruits and go to Chennai. A got stuck at Lucknow without any means of transportation or communication. A may assume powers of agent and do whatever necessary for prevention of the fruits. So this kind of agency arises out of necessity. In this case, A has not authorized B. B has not authorized A to do anything for the preservation of the fruits, but the situation has given him the powers. A may presume the powers of an agent depending upon the situation, that is necessity, because if he does not presume the powers of an agent to do the necessary things to preservation of fruits, the fruits may rot. So in this case, it arises out of necessity. It is not an express appointment. Third is conduct of the parties, that is implied agency or estoppels. Example, A went to a party. X said to Y in A's presence that he was A's agent. A did not refuse this. So Y may presume that X is A's agent. So A's being silent on the fact when X said to Y that he is A's agent, when A kept his silence, so it amounts to the presumption by V that X is A's agent. So in this case, act of the parties have given implied agency to X. PQRS were partners in a firm. If in P's presence, X represented to A that he was an agent of P's firm, but P did not refute this fact. A may presume that X is agent of the firm. In this case, he has got the implied agency of this firm, partnership firm, right? So it is a implied agency which is derived from conduct of parties. Let's discuss what are the duties of an agent. It's also for the theoretical purposes, how you will understand the scope of the agent's activity. First duty is duty to follow the instructions and custom. Example, A is appointed agent to sell diamonds of B. A must follow B's instructions in that regard. If there are no instructions, then he must follow the customs of a diamond trade, getting proper valuation done. So in this case, it's a duty of the agent to follow the instructions of his principal. Duty of reasonable care and skill. A is appointed agent to execute corporate contract. A fails to see whether the usual clauses are inserted in the contract. So A had failed the duty of reasonable care and skill. Whenever you are appointed an agent, you have to take the reasonable care and skill. So you must be pertinent, and you must take the reasonable care as a reasonable man is required to do while entering into any kind of contract. Duty to avoid conflict of interest. There must not be any conflict of interest between your agency work and your personal interest. For example, A is appointed agent of B to sell his land. A purchases the land for himself in the name of C. So there is a conflict of interest wherein he purchased the land which he was authorized to sell in the name of C. So the conflict of interest arises in there. Duty not to make secret profit. It's a duty of an agent that he must not make any kind of secret profit from the principal. B invites open tender for selling his property and A appoints A as his agent for this purpose. A takes bribe from C and accepts the tender. So A has made secret profit by taking bribe from C. So he is not allowed to do so under the principles of agency. It's a duty of agent, that is A, to not to make any secret profit. So let's take an example. Principal contracts entered into by the agents will have the same legal consequences as if they had been entered into by the principal in person. Let's take the facts. Dixie hires Probir to run his garment store. Here is the contract of agency starting here. To run his garment store for him, Probir goes to Meena Bazaar to purchase garments from the wholesaler. He does not tell the wholesaler that he is Dixie's agent. He also asks the wholesaler to send the bill to a specified address, whereupon it will be paid. The bill goes unpaid and the wholesaler discovers that Probir was Dixie's agent. He did not know this, so he discovers it later. He then sues Dixie. As a principal of agency, he then sues Dixie. Dixie claims that the wholesaler contracted with Probir in his private capacity and did not and not as an agent of Dixie. Can Dixie be sued? So in this case, applying the principle of agency, it's clear that Probir was acting on behalf of Dixie because he was running his garment store. So while buying the clothes for garment store, he was acting in the course of employment as an agent of Dixie. So whatever contracts which has been entered into by Probir with the wholesaler, the person whose principal here, that is Dixie, would be held liable for the agreements and contract entered into. So let's take the option A. Dixie will be liable since the item being purchased was clothes. No, this is not the question in here. B. Dixie will not be liable since the contract was entered into by Probir in his private capacity. No, Probir was acting on behalf of Dixie while buying clothes for his garment store. C. Dixie will be liable since Probir was his agent. This is the correct answer. That is, Dixie will be liable because he was acting as an agent in the course of employment of agency. So last one would automatically be struck out. Next concept which we have to discuss is contract of bailment. What is bailment? Bailment is a delivery of goods by one person to another for some particular purpose, which then when such purpose is accomplished, the goods are to be returned or disposed of as per the directions of the persons delivering them. So there are two words which would be used for the persons involved in the contract of bailment, that is bailer and bailee. The person who delivers the goods is known as bailer and the person to whom the goods are delivered is known as bailee. We will explain it with an example. A owns a DVD shop, right? B comes and takes the DVD on rent. Here A would be bailer who gives DVD on rent to B, and B is a bailee who receives the goods for the specific purpose, that is for watching the DVD, and it would be returned after the purpose has been fulfilled. So this is a contract of bailment. Let's take another example. A puts his jewelry and other valuables in a bank locker. Is this bailment? Yes. A has given the jewelry, that is a property, to bank, that is bailee. In this case, A is a bailer and bank would be bailee for the specific purpose, that is security purposes. So this is also a contract of bailment, and the goods would be delivered back to A once they are demanded by A. So the tricky area involved in here is the bailee is supposed to take as much care of the goods as would a reasonable and prudent man take of his own goods. It is not that the bailee can take a claim, take a defense that he took care of goods as he would take care of his own goods. But the point of view which will be used here is how a reasonable man would have taken the care of taken care of the goods of his own goods. So the point of view of Bailey is not used, but a reasonable man would be used to determine whether the reasonable care was taken or not. Let's take a problem. Principle: a Bailey is supposed to take as much care of Bailor's goods as a reasonable man would have taken his own goods. Facts: Manjeet agrees to keep Ramesh's car in his garage for the sum of ₹10 per day. So there's a bailment of Ramesh's car to Manjeet to keep it in a garage. Manjeet also keeps his own car in the same garage. One day, thief jumps the wall of Manjeet's house and unbolts the garage door, and after picking up the keys from the hook on the garage wall itself, drives away the cars. So there occurs theft. Ramesh sues Manjeet for the breach of contract of bailment. Manjeet points out that his own car was also stolen and the same care was given. So applying the principle, it is to be considered a reasonable man would have taken more reasonable care as compared to the care taken by Manjeet. He cannot take the defense that he gave the same care as that of his own car, but in this case he had not taken the proper care because the garage door was not locked, first of all, and second of all, the keys were put there itself. So somebody who would have entered into the garage has actually got the keys to the car also. So in this case, the reasonable care was not taken from the point of view of a reasonable man, not that of Manjeet's. So we have to decide whether there was a breach of contract of bailment by Manjeet or not. Let's take the options. A. Manjeet is liable because he should have taken care of both the cars. Right? Yes. It's not an answer because he should have taken care of the option is striked out because there's a word of he should have. The word should have means that we are talking about the possibility. So the act has already happened. We have to just decide whether he is liable or not and why he is not liable. We do not have to look into the factor that what he should have done and what not. So this is not an answer. Manjeet is liable because he did not take care of the cars. Yes, this is the right answer because he did not take the reasonable care of the cars, specifically the car which was given to him under bailment. So Manjeet is liable for the breach of contract of bailment. So C option is Manjeet is not liable since his car was also stolen. This is not the defense. Manjeet is not liable because he was not the owner of Ramesh's car. This is also not a right answer. So the right answer is Manjeet is liable because he did not take care of the cars. First answer is not correct because it talks about the possibilities. The possibilities are not to be discussed. It's just that we have to decide whether liable or not and why not. Next concept we have to discuss is partnership. Partnership in the partnership, how the principle of agency and reasonable care is used. All the partners are liable for anything that any of the partners does in the name of partnership and in the course of business. We have already discussed this principle of mutual agency. Mutual agency. It means that all the partners are liable for each other's act and they can act on behalf of the other partner and partnership firm. They share the profit of each other, but they also share the liabilities. So partnership is a concept wherein mutual agency comes into play and they can act on behalf of each other in the course of employment and on the behalf of the partnership firm. Let's take the example. All the partners are liable for anything that any of the partner does in the name of partnership and in the course of its business. They share profit of each other, but they also share the liabilities. A, B, C, D and E are 5 partners of a company, Kilos Fabrics, selling sarees. E, with the consent of all the partners, goes to the wholesaler to purchase 500 sarees of ₹100 each for the company. The wholesaler informs him that he would be charged rupees 80 per sari if he buys 600 pieces. E decides to go ahead with the deal without informing the other partners on the same and secretly makes money. Now the partners come to know of the deal and file a suit against E. So in this case, we will have to decide whether E can be held liable for the private profit or not. Let's take the options. E will be liable on the moral grounds. No, moral grounds are not to be discussed in this case. E will not be liable because anyways they had decided to spend 100 per sari. No, this is not an answer. E will not be held liable because it was his discretion to go ahead with the deal. No, the person is acting on behalf of the on the partnership firm, so he cannot take decision for himself and make secret profits. E will be liable to share profit because he acted in the course of business. This is the right answer. Whatever he did was he was doing on behalf of the partnership firm, so it's his duty to share the profit he has made. So by filing the suit against E, the other partners would make him liable for the profit which he had made during the course of business. So this is the right answer other than the other options. Next option we have to discuss is indemnity. Section 124 of the Indian Contract Act says a contract by which one party promises to save the other from loss caused to him by the conduct of the promiser himself or by conduct of the other person is called the contract of indemnity. The literal meaning of indemnity is to make good the loss. So the whole concept means whenever the person entering into a contract has some loss, the other person agrees to make good that loss. So it's called the contract of indemnity. The essentials of indemnity are: mere possibility of loss occurring will not make the indemnifier liable. Right? The person who agrees to indemnify the other is known as indemnifier. The mere possibility of loss would not make him liable. There must be actual loss occurring. Loss to the indemnity holder. Indemnity holder is the person who would be indemnified by indemnifier in the case of loss. The loss to the indemnifier is essential, otherwise the indemnifier cannot be held liable. The same principle is given again, that actual loss has to be there. Indemnity holder must have some loss which indemnifier would make good. The loss must arise due to the conduct of the indemnifier or any other person. The loss must arise out of the conduct of either indemnifier who agrees to make good the loss or any other person related, or any other person who is related to the indemnifier as per the conditions of the contract. The person who promises to indemnify is known as indemnifier, as we discussed, and the person in favor of in whose favor such a promise is made is known as indemnity holder or indemnity filed. We have already discussed the terms in the essentials. Examples: insurance contract. A contracts to indemnify B against the consequences of any proceedings which C may take against B in respect of certain sum of rupees 200. So this is a contract of indemnity. So A has agreed to make good the loss of B, wherein the acts of C has resulted in such loss. So it's a contract of indemnity. So thank you.